Hello, everyone, and welcome to What Business Owners Need to Know Before and During a Divorce. This will be a panel discussion with Cassandra Drake, Raphael Tashi, and Paul Woodhouse. We were supposed to have Shelley Bear with us, who's a divorce counselor coach, but she got ill, so unfortunately she can't be here. So Cassandra is a partner acting primarily as a family lawyer, employment lawyer, estate litigator, and she joined Lindsay Kenney LLP in 2014 and became a partner in 2019. She's the leader of the Family Law Practice Group and successfully negotiates settlements, separation agreements involving contentious parenting arrangements and the transfer of significant assets. So she's appeared on behalf of clients and assisted counsel at all levels of court in British Columbia. Then we have Raphael Tashi. He's a partner and head of Gowling WLG's private client services group in Vancouver. Raphael's practice is primarily focused on providing strategic legal advice to high net worth clients and financial institutions across all areas of estates and trust law. And last but not least, Paul Woodhouse. Paul is a chartered business valuator and CPA who's been providing valuation and financial advisory services since 1988. His expertise includes business valuations, litigation support, quantification of economic losses, and related matters. Paul has appeared as an expert witness before the Court of Queen's Bench of Alberta, and as well as at arbitration hearings. So for those of you here who don't know me, my name is Pascal Hansen. I am the CEO and financial strategist at Zeta, and I'm also a tech chair with Tech Canada. So for those of you who are not familiar with Tech Canada, Tech is the world's largest executive leadership development organization. It has over 28,000 members worldwide, and it's dedicated to increasing the effectiveness of Canadian business leaders. So being a Tech Canada chair means I facilitate monthly meetings with my CEO group, where group members learn from vetted experts like the ones we're going to hear from today. And they also form a peer advisory group to help each other with their business challenges. So a CEO group is not just for CEOs, it's for the ultimate decision makers in a business. So presidents, founders, owners of companies with at least 5 million in sales and a minimum of 25 employees. So I'm starting a new CEO group in the Lower Mainland. So if you're interested in joining, know anyone who is, please let me know. I would be happy to have a conversation with them. So to start off, back in, I think it was October, November, I was talking to different business owners that I know, and one after one, they're telling me they're going through a divorce. So I thought, well, I should educate business owners on what that means. Often your business is your biggest asset and has lots of implications for your business and, of course, personally. And then I spoke to another business owner and I thought, what do you think of us hosting an event? And he goes, Pascal, not now, because I know people that are going through a divorce, they're going to want to go through Christmas, keep the kids happy, and they're all going to file in January. I'm like, oh, interesting point. He goes, yeah, and I fall in that category. I'm like, oh, okay. And then I did some research and I saw January is called divorce month. So Cassandra, I don't know if that's true, that most people actually file for divorce in January. So that's why we're hosting this now. So I have lots of questions. So Cassandra, I'm going to start with you. So my first question to you, and thanks for being here, all my experts. Would it be correct to say that one of the most contentious issues in divorce is the division of business assets, if you are a business owner?
Yeah, if you're a business owner, I think that's fair to say. I mean, in fairness, I think the most contentious issue in a divorce is parenting. But if there's a business involved, yes, it certainly can be the most contentious issue in that particular proceeding.
And so from a legal perspective, what determines whether a company is a family asset or it's excluded as a business asset?
Well, it's not quite as simple as whether it's excluded as a business asset. I mean, everything that anyone owns may be considered a family asset, regardless of whether it's corporate in nature or personal real estate We have legislation in BC that came into force in 2013 that addressed what is family property or excluded property. And so anything brought into the relationship by one of the parties is considered excluded property. Anything received from a third party as a gift or inheritance is also excluded property, and there's some other categories as well. But so if something was brought, so if, for example, if you had shares in a company and you brought those into the relationship when the relationship started, those would be your excluded property. However, the increase in value on those assets during the relationship is considered family property. So you have an excluded property aspect of that particular asset, and you have a family property aspect. And that's where the valuation issues that Paul deals with for us come into play, because you need to know what the asset was worth at the time that the relationship started, and you need to know what it's worth now. So in terms of what's excluded and what's family property, as I say, anything brought into the relationship is excluded property, but increase in value is family property. And also, if the business is built during the relationship, which we see a lot, especially in lengthy relationships, people have been married for 35 years. You know, they built the business together, or one party built the business while the other party was, was managing the household, raising kids, that kind of thing. Then that asset is a family asset, and the entirety of the value is going to be divided equally.
Okay. And so can you explain how the structure of a business would affect the valuation? So whether business is incorporated or not, how does that play into it?
I mean, that's going to be more of a valuation issue. That's not really something that I would typically deal with as a family lawyer. That's where I would defer to
That's
Paul
and Paul. Okay.
Yeah, and we'd get evaluation. We'd get evaluation done. I mean, as a family lawyer, we'll take a look at things and say, okay, well, if they're not incorporated and they just kind of have a bank account, that the corporate funds, or the money that they earn goes into, then we just look at, for example, dividing that bank account, because there's not much more to it. I mean, there may be, there may be certain equipment that they use, that type of thing. But as soon as we start to get, it gets more complicated when there is equipment, and, if they are incorporated, that kind of thing, then we just defer to our business valuators to tell us what the company is worth.
So it's my it's
Oh, sorry, I was just going to jump in there with an example.
please do.
So the classic case for unincorporated versus incorporated businesses is the proverbial landscaping company, right? So you have Joe Wheelbarrow, who has 25 clients in a neighborhood. That business is going to be worth something, but it's going to be worth what somebody would pay for the 25 clients. And that typically amounts to about a year to a year and a half worth of revenue from those clients. And so we refer to that as the seller's discretionary income. And so it's the total amount that he earns. Somebody would typically be willing to pay at least a year to a year and a half worth of that income, as opposed to buying a wheelbarrow and trying to get all your new clients knocking on doors, trying to generate word of mouth, etc. So unincorporated businesses are typically very small and often don't have many employees. So they're not valued based on this, using the same methods that you would value a larger company with a workforce, a brand name, customer relationships, and that kind of thing.
Yeah, that makes sense. So,
and I just wanted to mention something else with respect to the previous issue on excluded property. Excuse me, I think I'm coming down with a cold. I had a recent case where there was a large family with 5 brothers. One of the brothers had been married for 20 years. There was 3 children involved, and the father was a very wealthy real estate investor who had set up a family trust 21 years ago to put 5 or 6 office towers into in a company, and then the trust collapsed in 2015, and the shares of the real estate holding company were distributed equally among the 5 children. And at that point, the 20% interest in the family holdings was worth $15 million, and that was considered excluded property. But between 2015 and 2022, the value of that real estate, those real estate holdings, his share went up $10 million. And so that was determined to be a family asset. And then, like you would expect, there was lots of negotiations around what the intentions were of the parents. And, you know, the stated argument was that money was intended for future generations and so forth, and it should not be included in on the wife's side. It was, no, that's clearly a family asset that began in 2015 and increased in value with the rising tide of real estate, and why should that be left off the table? So at the end of the day, there was a settlement, and it was not 50%, it was 35%. So both parties wanted to avoid the risk of going to trial and having the court or the judge determine something that was, you know, not reasonable or not bearable or whatnot.
That's very
Okay.
interesting.
Can
Thank-
I add something to Paul's point there, at least
Of
from my
course you can.
perspective?
Yes.
So I end up dealing with a big part of my practice is family succession and business succession within families. And that issue comes up a lot at the planning stage. And one of the recommendations and one of the conversations we always have is to put up in place shareholders agreements that forces your children to enter into marriage agreements and co-op agreements that protect family businesses. Because if the intention is that you keep the family business within the family, then we have to make shareholders agreements that enforce that document that, and we have to enter into marriage and spousal agreements that also do that. It doesn't mean that you don't provide other alternate assets to satisfy your family law obligations if you go through separation or divorce, but it means that you protect the family business for the family. So I just wanted to add that to Paul's comments because I thought it was really apropos.
Well,
Yeah,
I think that's important too, because I still come across a lot of business owners that they don't have a shareholders agreement. And so when I come in and want to talk about life insurance, I'm like, what is your shareholders agreement? And they're like, oh, we haven't done that. And we started the business on a handshake. And I'm like, well, you got to start there. So, yeah.
And you see that a lot within family businesses because the concept that every shareholder is a separate entity doesn't always feel this. It doesn't resonate the same way within family context.
Yeah.
And sometimes closely held businesses, even if it's not family, that same idea, you see that appearing a lot.
Yeah. And so I have a question too. I get a feeling, and I don't know, that prenups aren't very popular in BC. And so Cassandra, do you see that a lot? You're going to divorce and most people have them or not? I have heard they're not worth much in BC, and this is all anecdotal, of course, but I've heard people say, well, if you want a prenup, go to Alberta to get it done somehow because they're better there. So please dispel myths. I don't know.
Yeah, excuse me. They're becoming more and more common. I mean, they've always existed. We've always had what we call cohabitation agreements and marriage agreements. In my view, they're becoming more common, and that I think stems from the fact that real estate is so expensive in the Lower Mainland, and people are getting gifts from parents, typically, or grandparents, or whoever, to purchase property that they're then going to reside in with their spouse. And they want to protect, the money that they've been gifted to purchase this property. So we're seeing them more and more in that respect. We also see them, as Raphael has pointed out, with respect to family businesses. I've done quite a few where there's family businesses that are, have significant value. And often the parents of the person that I'm doing the agreement for are adamant that an agreement be done. So I'm often dealing with people who don't necessarily want to do an agreement, or they don't really see the need for an agreement, or they feel bad, that they're having to do this to their spouse and have an agreement drafted up, but their parents are insisting on it. And so they're becoming more and more common in that regard. My initial contact is often with parents, and not actually with the person that we're going to be doing an agreement for, which is interesting. But they're certainly very important in those respects. And again, just with the price of real estate, and gifts that people are getting, it's important, and they're much more, they're much more common, especially as we know, just because of how quickly and substantially real estate increases in value. Under our legislation, as we talked about, the gift would be excluded property, or anything that's brought into the relationship would be excluded property. But there's such significant increases in short periods of time. Like, we often, are dividing, if people don't have an agreement, someone's house went up $600,000 in value in 2 years, and now they have to buy out their spouse. They have to pay them out $300,000, and they can't necessarily afford to do that. So they're becoming more and more common. In terms of, how much weight they carry, it's certainly not the case that you would go do an agreement in Alberta. I mean, you just wouldn't do that, because the law is different in Alberta. You need to have an agreement that applies BC law, and you'd want to have a BC lawyer doing that. If the parties are located in BC and the property is located in BC. The key to having agreements upheld is that they're fair. And so Raphael made a good point, just in terms of family businesses and excluding someone's, excluding entitlement to a family business, or an increase in value in shares, or whatever it may be. As long as it's fair, as long as there's some other compensation, the court will uphold the agreement. And so what we typically do, I mean, if you end up having, for example, a 35-year relationship, and you're just trying to essentially exclude entitlement to everything, yeah, the agreement's going to get set aside. The same goes for, I did one recently for someone who had an interest in the family business, which had significant value, hundreds of millions. And we came, obviously there were lots of discussions about it. Ultimately, I mean, he wouldn't have had enough other assets to compensate her for what would likely be her interest in that company. So what we often do is we do kind of an incremental entitlement to the increase in value. So, if you're together for 5 years, you get, 5%. If you're together for 10 years, you get 10%, whatever percentages we decide are fair. And that way we're pretty confident that, a court would find that agreement to be fair and uphold it, even though they're not getting their 50% of the increase in value, just because the increase in value can be so, so significant. So agreements are definitely a good idea where someone is bringing assets into the relationship, or expects to inherit or be gifted assets during the relationship, and they will be upheld if they're fair. And I know that's, that can be difficult to interpret, and different judges interpret it differently. But if you take kind of a common sense approach to it, I think you can come to something that would be viewed by the court as fair. And the other party should always get independent legal advice. That's another key aspect. The court wants to see that they knew what they were giving up, and that they had legal advice on that. And that goes a long way to ensure that your agreement is upheld. So so sorry, that was a kind of a long answer to are these agreements being done, and are they being upheld? And they are, and they are being done more frequently, and they are being upheld.
Well, that's good news. What happened?
Sorry, Pascal, can I add to something to Cassandra, at least from the state law perspective?
Yeah,
because I agree with Cassandra. It's getting done. I would say in the last 3 months, I've recommended at least 10 clients get either co-op agreement, or spousal agreement, or some kind of marriage agreement, right? And I'll give you context. So I think the examples matter. So I have an entertainer client who is 20 years old. She's just signed a deal with Sony and a bunch of entertainment companies that I know is the beginning of something big. She lives with her boyfriend, but they're now about to cross the threshold where they become common law. And so because of the context of her life, co-op agreements are a really important piece, because she's about to build this empire and she's on the threshold of something great. And so I got that client because the agent that signed that person that says, I know what's in the pipeline for this person needs protection. So we structured her affairs, we created companies, and as part of that, we paid for her partner, boyfriend, to go get independent family law advice. And we recommended her to a family lawyer to come up with a cohabitation agreement so that it covers the unexpected. That's one example of a very young person getting a co-op agreement. I have another client whom I refer to for a co-op agreement, who one of them has come from a previous relationship with 3 kids. The other one, this is their first spousal relationship, and they're bringing in significant assets. And they've agreed, we don't need anything from anyone. I don't need spousal support. I don't need any estate. If you died, I don't need anything from your estate. But all of that, you need to document in some kind of agreement. And why is that important? It's because in the estate's context, courts determine what a spouse's obligation is when a spouse dies, what the obligation is to their surviving spouse out of the estate. There's a legal obligation and there's a moral obligation. What I'm talking about next is really the legal obligation. A lot of the time when the court considers what your legal obligation is, if you have a marriage or cohabitation agreement, that goes into the analysis, the court's judgment of what your legal obligation might be. So it might be that in the blended family context I just described, the clients have both agreed that we're both independently financially safe. We don't need anything from anybody else. Our context hasn't changed. And that I have these other obligations because I have kids come from a different relationship and that I don't want to impact you. So I want to document what we owe for our legal obligation to each other if we died. The court will consider that. It doesn't mean that what you've set out will be the result, but at least it's part of that analysis. And it's better than if you don't do anything at all. So those are kind of 2 extremes. I've had families, Cassandra's examples where families are driving the co-op agreement. I've had one family with a large charity foundation and significant wealth where they know their kids are going to, and every child, once you live with somebody for a year, they force you to enter into that agreement. And we've referred 2 of their kids for that agreement exactly, right? So I think we have to be more aware of these agreements. We have to be more accepting of these agreements. And in the family business context, a lot of the times, what I tell families is, it's hard for your child to go to a partner and say, I want you to sign a co-op agreement, or I want you to sign a marriage agreement. It's a lot easier to say, my mom is making me do it, or my dad is making me do it.
Yeah.
Right? And that if I do it, I'm going to get $15 million, using Paul's example. And that, even if it says you're not going to inherit the business, so long as we're together and we have a family together, they benefit from their protected assets, right? So my view is, we have to look at these agreements as tools in planning and helping families get over the difficult stages of life. And sometimes it's just, it's life insurance, right? It's an insurance against the unexpected. So I'll stop there. I've talked a lot, but I just thought I wanted to, what Cassandra was making, the point she was making was fantastic.
No, but that's really great examples. And I would just add to that I've seen people not earning a lot of money, then something happens in their career, now they have a lot of money, and vice versa. So I would always say to anyone to protect yourself. You don't know what's going to happen in the future. Too often I hear someone go, I don't need a prenup because I only make this and the other person makes more. That can change. So Paul, I think you wanted to say something.
Oh, I was just going to say, I've seen quite a few examples of that, of young, starry-eyed, romantic couples, and then their parents are breathing down one of their necks, and they don't want to bring up the whole idea of a prenup, because let's face it, it's a buzzkill when you're just getting married at a young age. But if you could say, look, this is the only way we can move forward because my evil father is demanding this, then that's usually what happens.
It's always nice to have a fall guy, right?
That is right.
Well, and I'll just say that typically what I say to people is, even instead of making the parent the evil person, because they're going to be the in-laws for the rest of these people's lives if they stay together, I always say just blame the lawyer. Say my dad's lawyer, my parents' lawyer says that we have to do it. He or she is telling them that this has to be done. So I always just say blame the lawyer, because I don't care. I'm fine with that. And people are typically happy with that. They're typically happy to be able to say, that terrible lawyer. So, so that's the way that I typically do it.
That's even better. Then you don't have awkward conversations over a Christmas dinner.
That's right.
Yeah.
Cassandra and Raphael told me to do it.
Exactly. And one further point I just want to make about agreements. I often have people come and want agreements, their parents want them to do agreements. And an issue that we run into is the importance of disclosure. So oftentimes parents say, well, I want my child to do this agreement. And I have discussion with them about how important full disclosure is, because the other spouse, will not know what they're giving up if they don't have full disclosure of what exists. And so I often, all of a sudden it's like, oh, we have to set out the value of the business and our, whatever it is. And it's like, yeah, you do. I mean, if it's anything that, your child may be receiving, value that your child may be receiving, or already has an interest in, then you have to provide disclosure of that, because otherwise you run into an issue of the agreement not being upheld, which we were speaking about previously, because the court says, well, even though they got independent legal advice, they didn't know, the lawyer didn't know because they didn't have disclosure, and therefore the party didn't know what they were giving up. And so I often have people become very hesitant about providing that disclosure to this, this new spouse. They've been together for a year or whatever it is. And they're like, well, we don't want to tell this person that we're worth, $50 million. But it is key that they understand what they're giving up. So that's sometimes a tough conversation that I have to have with parents in particular, because they usually, still have the majority of the wealth, but it is very important. So just something to think about.
And I would just say, for anyone listening, if you're thinking I'd be married for 10 years and never got a prenup, you can't get a postnuptial agreement. So, right?
Well, you can always do a marriage agreement. I mean, even once you're married, you can do a marriage agreement. The issue is that you lose any leverage that you have, as terrible as that is to say, that may come from saying, okay, well, I'm ending this relationship and you have no entitlement. You've lost that leverage if you've been married for 10 years. And it's not to say that you can't do it. And people do it. If you have two reasonable parties, and one party says, well, I'm going to be inheriting this and I want to make sure that, that it's protected, or the parents say, you're going to inherit this, you should make sure it's protected. Sometimes, the other party will agree to that if the agreement's fair and it provides, for that spouse. It's just that, frankly, and this is why we sometimes have a rush to have marriage agreements or cohab agreements signed right before that 2-year mark, because now you've lost your leverage of saying, okay, well, we're not spouses, you have no entitlement under the legislation, so I'm ending the relationship. So yes, better to do it sooner rather than later, certainly, but it's not, completely off the table down the road.
So what happens if a settlement isn't reached, Cassandra? Like
what happens if it?
Yeah, like if in a divorce, so if the person's not being reasonable and digging in their heels, what does that look like? Can that take several months, years?
So a settlement where people have separated?
Yeah.
Well, ultimately, you're going to have a decision, because if people can't agree, then you go to trial and a judge tells you what's going to happen, which is, in my view, and I always tell clients, it's never beneficial to go to trial because it's extremely costly. It's very risky. You never know what a judge is going to do. I mean, judges are humans. They can, take a liking or disliking to either party. And we sometimes get some surprising decisions out of trials that, neither lawyer expected. So you will always have a final resolution, because you will go to trial if you can't, reach one yourselves. But, it's always preferable to negotiate a settlement, as Paul mentioned, in terms of sharing that increase in value. I mean, that is always preferable.
Yeah. So
Pascal, sorry, can I add? I want, Cassandra made 2 points to the first question, the last question, and then this one I think I'm really curious about Paul's thoughts on a point, because post-nuptial, when I've come across and we've recommended it, it's always because of predictability, right? We tell the client, we need to know, if you have a family business, you need to know what your potential liability is going to be if you go through this event, right? And so the conversation at the time is, let's come up with a settlement, a solution that we can plan for so that doesn't impact the business when it happens. That almost always is driven by tax considerations, right? Because if I had to split the company up and give you 50% of my shares or something like that, there is a tax issue to consider. And so some of that, I'm curious, Paul, to see if you've come across that and how, if that becomes part of a planning conversation, or is it usually post separation that's when you're looking at that issue?
I think it's always considered, tax effects are always considered during the negotiations, pretrial negotiations. In many cases, depending on the asset involved, there are tax planning opportunities to avoid or defer paying the tax until the future. And one recent example was a case where there were several companies involved. Some were operating businesses and others were real estate holding companies. One of the real estate holding companies had increased so much in value that it was possible to remortgage the properties to generate enough cash to pay the spouse her 50% interest. And instead of selling a property and incurring the capital gains tax, what they were able to do was the wife was able to set up a holding company. And it's a lot more complicated than I'm saying right now, but essentially the wife sets up a holding company, subscribes for shares in the real estate holding company, and then those shares are redeemed for a high dollar amount, basically transferring tax-free money into the spouse's holding company. And then when the spouse wants the money taken out of the company, that's when the tax is paid in the form of a dividend tax or a salary tax, whatever method she decides to draw the money out. But it was possible in that case to structure the settlement such that no income taxes were paid up front, that they'd be deferred into the future as the wife needed the funds. I'm not sure if that answers the question or not.
It does. It's because a lot of the time when we're dealing with post-nups, it's really driven by tax conversation. And it's not like, yes, the marriage issue, the spousal relationship breakdown matters, but really because we want predictability around the value, the asset that's going to go, and any tax obligation that might arise. And so we're having that conversation, even though it's a little late, as early as we can to plan to put in place a tax roadmap.
Oh, I see. Okay.
So Paul,
Yeah.
can you touch a little bit about how a business is valued during a divorce and what factors affect company valuation?
Okay. So it's important to note that a business is valued the same way, never mind if there's a divorce or not. So the fact that you're going through a divorce doesn't alter the valuation methodology or the conclusion or anything like that. So there's essentially three methods to value a company, and it really boils down to the nature of the company that you're valuing. And so those methods are the income approach, the market approach, and the asset approach. And so if you have, let's talk about the income approach. So this would be used when a company is generating free cash flow that is available to the investors, right? And that's in contrast with a property holding company that does not generate a lot of cash flow. And so for a property holding company, you would use the asset approach, which essentially involves taking the balance sheet and adjusting the book value of all the assets and liabilities up to their current appraised fair market value. Under the income approach, you're really looking at what the future earnings of the business are going to be. And so if it's a fairly young business that's been growing, you would use the discounted cash flow approach, where you try to estimate the future earnings of the company, which are going to be higher than they are today, until at some point it stabilizes and levels out. If the business is a mature business that generates, roughly the same amount year in, year out, you would use the capitalized cash flow approach, where you're essentially picking one level of cash flow and capitalizing it under the assumption that it's going to continue in perpetuity into the future. So that's the income approach. The market approach is essentially basing the valuation on comparable transactions involving other similar businesses. Okay, so we have access to various transactional databases that show, for example, an oil field services company. It's a very common type of business in northern BC, northern Alberta. And we can tell what investors are currently paying for those types of businesses as a multiple of their earnings or as a multiple of their revenue, etc. So, but the problem with the market approach is that can sometimes be difficult to find comparable company transactions. So if you're dealing with a very common type of business, like an A&W franchise, or a mechanics shop, or a tire store or something like that, you literally find hundreds of transactions involving those types of business. So using the market approach can give you a very high level of assurance that that's what you would get if you brought the business to market. But if you're dealing with some kind of odd business that there's not many of them around, like like a biotech company involving some kind of unusual drug that no one else makes, or a software company that there's no other company that does this, then you can't use the market approach. And so the third method is the asset approach, and that is essentially, like I mentioned, taking the book value of all the assets and liabilities and adjusting it to fair market value. And so that's when we call in the real estate appraisers that know how to value physical property, because a business valuator doesn't do that. That's a different discipline. But along with that, I mean, it sounds like a very simple methodology. You just adjust the book value of the real estate to fair market value. But along with that, there's a lot of tax considerations, like Raphael mentioned. When you sell a property, you have to pay capital gains tax. You have to pay tax on the recaptured depreciation that you claimed in the past, and the list goes on. So those are the three methods of valuation. Does that make sense?
Yeah, that makes sense. And so from a tax perspective, is there any way you can protect your corporation from divorce? Like,
not really.
not really, right? No.
Yeah.
Yeah.
I mean,
Don't do it.
Yeah.
Don't do it. Don't get married. What?
Don't get married or don't get divorced or
Okay,
separated.
got it.
And don't let them move in longer than 2 years. Is it still 2 years, by the way?
Yeah.
Still 2 years, 24 months. Okay, so put that
Mhm.
ticker.
Can I actually, that
Put it in
comment,
your
let me
calendar.
clarify that. Maybe Cassandra is really good at, will be the better person to explore the conversation. Because I've had clients that think moving in for 2 years alone makes you a spouse. There's a broader definition of spouse. That does not mean that you have to live together. And I've had clients that fit, I've been with this person for 15 years, we're boyfriend, girlfriend, or whatever you call yourselves. We don't live together, but we present ourselves to the world as spouses or like as partners.
Yes.
This client, for me, that client was a spouse.
Yes. I mean, that's a good point. We have quite a complex analysis that has to be done of whether or not someone is a spouse. And it's being done frequently, just, as I said, given the fact that real estate increases so significantly and people are like, well, we're not spouses. Yes, it's not simply, you know, if you live together, your spouses, if you're not, you aren't, or sorry, if you don't, you aren't. It's much more complex than that. And Raphael, you're right. I mean, as you point out, when people have been together, you know, for a number of years, and they say, well, we don't live together. There are a number of other factors that are considered as to whether or not your spouses. And the other thing I often raise with people is, you know, they say, well, I've kept a separate address, but you then find out that they spend the majority of their time at their spouse's home or vice versa. The fact that you kept a separate address, you know, so, and you have your mail sent there, isn't going to be determinative. So yeah, I mean, we deal with these types of things all the time, and I'm always very careful to tell people that, you know, it's not that simple. And and frankly, if you are in a relationship with someone, you need to consider whether or not you're spouses. Because
So
relationships,
you're saying, Cassandra, sorry to cut you off. If you've been living or in a relationship with someone 15 years, you spend most of your time at your significant others. If that relationship falls apart, does that mean that other person now has to pay alimony because it was like a spouse-like relationship? Is that what you're saying?
potentially, if they meet the definition of spouse, they're entitled to spousal support, potentially, if there's entitlement, you know, if there's disparity in income and those types of things, and property division, which is, as we say, typically the biggest one, where people own property. So we deal with this frequently. We had a file where the two people sailed together. They lived separately when they were here in Vancouver, one in West Van and one in Kitts, but they sailed together on this sailboat for the majority of the year, and the court found them to be spouses, and he had to pay her a percentage, not 50% of the increase in value. We were able to argue it down to a lower percentage because it was a short relationship, and she didn't make any contribution. But you know, they sailed together. That was the extent of them living together. They didn't even live together when they were in the Lower Mainland. We have one going on now where there's a lot at stake. Our client's worth about $160 million. So the increase in value during the relationship was, you know, between $15 to $20 million. So it's being litigated. We did 6 weeks of trial in September. We have another 2 weeks in February. And the biggest issue is whether or not they were living together in a marriage-like relationship for the requisite period of time, because she had her own condo elsewhere, but they traveled together. He has a private jet. He has houses, you know, he takes people to concerts. They traveled together so much during the period of time that he says, well, we weren't living together, that, you know, there's a serious dispute as to whether or not they meet the 2-year time period. So, yeah, you really have to be careful. And I say to people, if you've been in a relationship and it's approaching 2 years, you really should, you know, think about getting an agreement. Speak to a lawyer about whether or not, you know, you're at risk, but you probably are, because the court has taken a very flexible approach to what is a marriage-like relationship. It's no longer, you know, we live in a different world than, you know, people get married and have kids and move in together. Like, people have very different relationships. I know people who are married and they live separately. They have 2 separate houses. They're married, but they've done this for 20 years. So things are just different now, and the court takes a much more flexible approach to what is a marriage-like relationship.
So what would that look like?
Sorry, Pascal, can I explore that, just because it's,
yeah.
So the other piece, so 2 points. The first point is the opposite can be also true.
Yeah.
You can have people that live together who are not spouses. Right? And we've just finished a file. It was for tax reasons, where we had to argue that although these 2 people are in the same house, one lives upstairs, one lives downstairs, and their lives are separate. So Cassandra's points are exactly apropos, but also know that the opposite can be true, which is we can be in the same house and not be spouses. And then the other piece that I wanted to add to the conversation is that you can also have multiple spouses, especially for estate purposes. Right? You can have, there's cases where the person was married, never divorced, and then left and formed a marriage-like relationship with somebody else. And under BC law, spouses have special claims to an estate. So in this instance, you have 2 spouses with equal claim to that estate. So we have to know that the definition of who a spouse is, it's really important, and it's flexible, it's nebulous, it moves. And so in a lot of cases, we're exploring the facts to figure out where we are, who's a spouse, what rights might they have. And if it's before a claim, then we're trying to put in place agreements, conversations, understandings to deal and to deal with that scenario. Or we're saying this is easier for you to, this relationship is spousal, but you can leave, and the cost might be a little bit less than if you stayed, right? But it's really interesting conversations to have with clients around the nature of relationships, because they're not, we talk about them as if they're static, and they are not. And we really kind of have to, as professionals, we have to always think about the nebulous and fluid nature of relationships.
I think that's fascinating. What about the case if you are just traveling with someone, you're the business owner, you live in BC, but your person that you're traveling with, or your spouse, maybe they reside in Spain, then what?
I have a fact. So the question I asked Cassandra is exactly on those. I have a client that's exactly in that situation. They are CEO of a mining company, and they are with somebody in a different country where they spend a lot of their time with, especially when you're in that country, and they represent that person as their partner, right? That person was here.
So where does the trial happen? Like, is there an agreement? Like,
so for me, thankfully, I don't deal with the fights. I deal with, let's plan for this.
So Cassandra, so where do you fight that battle if it's
Well, I mean, that's a jurisdictional issue, and it's not kind of a cut and dry answer in terms of which court takes jurisdiction. I mean, typically the way the jurisdiction works is if there are assets in a particular jurisdiction, then it depends on what type of assets they are. So real property, typically the courts in that jurisdiction have jurisdiction over real property because it's immovable, we call it, as opposed to bank accounts, cash, that kind of thing. And so it depends on the type of asset, and it would depend on, I suppose, the type of asset that the corporation owned, as to which court would take jurisdiction. And oftentimes it'll be like who files first, depending on which law is more favorable. But you also have to be located in the jurisdiction. So you couldn't just go and file in, California, for example, if, as you've said, you have a business here, one of the parties here, and then one of the parties in Spain. So oftentimes it'll be who files first. And then there's a battle over jurisdiction right at that point. But it can only be in the two jurisdictions that the parties are located in. And then the court decides whether or not it's going to take jurisdiction after the parties fight it out. And typically, if there is, as I say, real property, the court will take jurisdiction over that property. But it doesn't mean that a court in another jurisdiction can't take jurisdiction, because what they will sometimes do is say, we have this often. My colleague has a lot of clients, Chinese clients, and they will have property in China. So the court here can't take jurisdiction over the real property in China, but what they can do is say, well, that property, we get that property valued. That property, is worth X dollars. So because we don't have jurisdiction over it, what we'll do is reapportion assets that we do have jurisdiction over in Canada. So it's quite complicated. It depends on a number of different factors, and of course the type of assets that we're dealing with. So yeah, not a cut and dry answer. But if you do an agreement, a cohabit or a marriage agreement, you can specify which jurisdiction applies. And so we tell people to do that. I don't know what the laws in Spain are, so I don't know whether or not it's more favorable, to have BC law apply or the law in Spain apply. But when you're dealing with someone with significant assets, you'll normally get an opinion, right, in terms of what's more favorable to them. And then you may have a dispute with the spouse trying to get the agreement done. But it's best to specify what law is going to apply, and then you don't have that jurisdictional battle right off the bat.
It's so interesting.
Sorry, to Cassandra's point, the smart part of this is not to deal with it at the end. is to
Yeah,
deal with it up front.
yeah.
So the example that I used, what we looked at was our client was mostly based in BC. Our client's assets are mostly based in BC. BC law for a spouse's claim to somebody's estate is really favorable, right? And so regardless of what the other jurisdiction is going to do, we know it's likely that that person is going to come here after the assets here. So what we wanted to do was protect our client from a BC law perspective, so that we didn't have to even do the analysis. We still recommend go talk to the lawyer, like get a lawyer and advice on the other side to understand what it might be, but BC law is really favorable to a spouse. And so it's conceivable that the claim might be legitimate, so your estate might be responsible for paying for that person's cost, right? So the incentive, it's really here. So the plan was to then consider, how do we protect our client from a BC law perspective, because it's really favorable to this if that person meets a spousal definition. And my argument was, the client was, I'm not a judge, but it's highly likely, given the facts you've given me, that a judge might consider you in a spousal relationship because you call that person and represent that person as such, even if they're not here. Right?
It's
And
fascinating.
so you kind of have to think about these things.
So what I'm hearing is that if you're in a relationship, you got to put a timer on that. How many months have you been in the relationship? You got to talk to Cassandra. And again, it's always planning. The more you plan up front, the better you are. So in the interest of time, I want to open it up to questions. So I'm going to call on Christine. Do you have any questions?
No, you guys have been so thorough, and it's quite refreshing to be able to have a conversation about divorce without anyone getting heated. And being just flatline factual, and having great background that has background stories, because that really solidifies the data, the simple data that can be quite boring. It solidifies, oh, okay, so I know that my friends X and Y are doing that, and I know she's kind of concerned and he's not said anything. So it actually, gives friends and family fuel to say, hey, that thing that you assumed was the way it is, it's not.
That's great. Awesome. Charles, thank you, Christine. Charles, do you have any questions?
No, I have learned so much in the last 45 minutes. I really do appreciate it very much. Thank you.
Okay, thanks. Joey, you're in the divorce world, recovery from divorce. Do you see a lot of the pain and suffering coming from not planning ahead of time?
Definitely. Yeah, I think that a lot of I learned a bunch of stuff today too. And yeah, it's interesting when you talk about cohabs. Everyone that I know that has one, they said that it was the best thing for their relationship. We said what needed to be said, we got it out of the way, and everything is clear now. So yeah, I'm a huge believer in planning going forward. But yeah, I think that there's people just love to get themselves into sticky situations, don't they?
Right. But I think
One thing,
that's a key point, like the peace of mind. Nobody ever talks about that. People feel awkward having money conversations, but nobody ever mentions, well, you put it on the table, we have a frank conversation, we're going to feel better, right? Nobody focuses on that. Paul, you were going to say something?
yeah, I just wanted to raise one other point that's I think quite important, and that is the valuation date. Okay, so that's the date of the valuation. And what I'm seeing lately, for some reason, is notwithstanding the family law rules require the valuation date to be as at a current date, a lot of divorcing couples are wanting to value the business at the separation date, the date that they separated and moved into different locations. And they're surprised to hear that no, you separated 4 years ago, but the value of the company's gone up $5 million since then. And unfortunately, it's the new current valuation that is included in the family property. So that's a really important issue, I think.
So I have a question from Christine regarding valuation. Would it be practical to have the business valuation done annually, regardless of any issues?
That would be pretty costly, I think.
Yeah, I
Yeah,
was just gonna say that. If you have deep pockets, maybe, but
Yeah,
I mean, yeah. I mean, like when I'm talking about my client that's worth $160 million, I mean, it probably would have, made sense for him to just do that regularly. I just want to speak to that point about valuation date. And Paul's exactly right. Our legislation says the valuation date for family property and excluded property is the date of trial or the date agreement is reached. So current date, which some people find very frustrating simply because it can take 2 to 3 years to get to trial. And even if you are full steam ahead, both parties decide they want to go to trial, neither party is intentionally delaying, which we see a lot. Given the shortage of judges, we often, with lengthy trials, and whether there's business valuations, they tend to be lengthier trials, we get bumped, we don't get a judge. And then we have to set the trial for another 1.5 years down the road. So, first trial was 1.5 years down the road, second trial is another 1.5 years down the road, you're 3 years down the road, and people can't wrap their head around using the current date when the value of the company has gone up $5 million. Like, how is that fair? There is, in our legislation, there are arguments that can be made, significant fairness arguments, and actually a provision to use a different valuation date, but it's an uphill battle. So we sometimes will get the business valuated at the date of separation where someone is adamant that that's the value that should be used, and they're going to argue that one party has delayed this 5 years and they're not entitled to the increase in value in those 5 years. But yes, by default, it is date of trial or date of agreement, and that can be hard for people to wrap their heads around.
so it's up to one of the spouses to prove to the court that there would be significant unfairness in,
yeah, thank you. Yep. Any questions?
No questions. But like I'm a business coach, and I work with business owners to increase the value of their business, through all the operational and organizational change. And so for me, this is useful to understand, to know just enough, for owners that they need to take care of these things. And so if I'm in a situation where I get concerned, then I can refer them to, one of the folks in this group. So from that perspective, I would like to get in touch with all of you. Is there a way to get
I'll send you their contact information. Yep. And yeah, for all your business owners, they got to talk to Cassandra, get that paperwork done.
Right on.
Yes.
So thanks for organizing, Pascal.
No, absolutely my pleasure. Thank you so much to my esteemed guests and for everyone that showed up. I really appreciate it. And yes, watch for a follow-up email. Thanks,
Thank
guys.
you so much, everyone.
Guys.
pleasure to be here.
Thank you,
Bye-bye.
guys.
Take care.
Thank you.